and frank talk of a sexual nature. Viewer discretion is advised.
The state rocks the courtroom with one final, potentially devastating piece of evidence, and the defense catches everyone, I mean everyone, folks, by surprise. Hello, I'm James Curtis. Welcome to E's coverage of the Michael Jackson trial. The King of Pop looked just a bit frail as he walked into the Santa Maria courthouse along with his parents for what turned out to be the last day of testimony in Santa Maria. We're going to pick up with one of the state's last rebuttal witnesses, William Dickerman, the former attorney for the accuser's family. Under questioning by Assistant District Attorney Ron Zonin, the witness describes a letter he sent to Michael Jackson's former lawyer, Mark Garagos. Here's how the jurors heard it according to the courtroom transcripts.
All right. In that letter of April 9th, 2003, do you reference passports, visas, and birth certificates?
Yes.
Actually, you demand their return to your client. Is that correct?
Yes. I asked that he, quote, immediately deliver to me, along with the documents you just mentioned, some other items.
Now, the next page, again, as we acknowledge, was the transaction report on the fax machine?
Yes.
Did Mr. Garagos, up to this point, either by telephone or in any other communication, indicate to you anything about passports belonging to your clients?
He, in one conversation, I think it was on March 31st, I asked him about passports and visas, following up on the letter that, well, when he called me because he wanted additional time to respond to the March 26th letter, we talked about it briefly. He didn't exactly know what I was talking about. I think he said that there were passports around that he had heard of, but he didn't know what it was, what that was about.
Okay.
I understood he was going to find out and get back to me. He never did.
Did he ever?
He never got back to me on that. He never responded to any of my letters asking for any of these items, except for the items in the storage unit.
All right. As the cross-examination gets hotter, the paper trail gets a little colder.
Have you been in touch with the prosecutor about these letters before you testified today?
Yes.
Did he ask you to look in your file to get copies of your letters?
I'm not sure, but I told him I had copies of my letters.
Did he ask you to look in your file and look at the copies of the letters you claim you sent to Mark Garagos?
I don't remember specifically.
So far, there is no copy you've been able to find of a March 26th letter that you actually signed, true?
Yes.
Yet we have other letters in this package that you did sign, right?
That's right. And as I explained, they are copies of precisely the document that I faxed. I would not fax a document without my signature. However, I did messenger the document with my signature.
How do you know that if you don't have a copy of the signed letter?
Because I sign my letters before they go out.
Where's the copy?
I didn't make a copy of my signature. There's no reason to make a copy of my signature. These copies are faxes that were sent, that were faxed. They are faxed, obviously, with my signature.
You and your client were trying to set up Mr. Jackson for a lawsuit, true?
Objection. Argumentative.
Sustained.
Did you have your profit-sharing arrangement with Larry Feldman at this time?
Objection. Argumentative.
Beyond the scope?
Could I respond to that?
No, it's beyond the scope. Next question.
Your Honor, could I correct a statement that I made in a previous testimony? Because it seems to make a big difference here to Mr. Mesereau.
Your Honor, I think with all due respect to the witness...
Next question.
All right, we got a judge who's now clamping down on the order of this courtroom.
It happens
Seems
from
to be in
time to
control.
time. It does happen from time to time. And after all, this is rebuttal, and rebuttal is specifically for the purpose of dealing with something that the defense brought up. The defense brought up Mark Garagos. He came and testified. He says he's in charge of the surveillance. And the prosecution wants to show that, well, perhaps Mr. Garagos didn't tell us everything.
Well, perhaps he's holding back a little something, and that makes him look like what?
Well, this witness, Mr. Dickerman, doesn't really offer a lot of substance. What he does do, it seems to me, is impugn the character and the credibility of Mr. Garagos, who we remember was a very good witness for the defense.
All meaningless to me. Proves Mr. Garagos was non-responsive. Doesn't have to be non-responsive to everything. Evidently, he made the furniture, whatever else in the storage units they wanted available. And secondly, the dialogue about copies of the letter, you sent the letter, but you don't have your signature, meaningless to me and doesn't go to any issues in the case.
Lawyers bickering back and forth.
Yeah, and this whole thing sort of like the little snitty fit in between the attorneys. Can I answer
Let's
that?
get
He knows
on
the
with
judge.
it.
Yes, indeed, and we're going to get on with it. Wait till you hear about how this case ended up for the weekend. I can hardly contain myself. Up next, former community newspaper intern Christine Causer under questioning by District Attorney Tom Sneddon. The witness recalls her dealing with the accuser's family. Now, does she contradict earlier testimony by the editor of her paper?
Now, at one point in time, did you work as an intern for the Mid-Valley News?
Approximately 4 or 5 years ago.
And was the person that you worked for Connie Keenan?
Yes.
She was the editor at that time?
Yes.
And you're familiar with Mrs. Keenan?
Yes.
And in connection with your work with Mrs. Keenan, did you become involved in writing an article for the Mid-Valley News?
Yes, I did.
Now, I want to ask you some questions, some specific questions. Did you ever tell Mrs. Keenan that you had delivered a cooked turkey to the family?
Not a cooked turkey.
Okay. You delivered a turkey, did you not?
Yes.
And when you delivered that turkey to the did you also give them some money?
Yes.
How much did you give them?
$5.
That was a lot of money to you at that time, wasn't it?
It was. Well, it was somewhat, not really a lot, but it was a token amount, really.
Did you tell Mrs. Keenan that you had done that?
Yes.
And did you get in trouble for doing that from her?
Yes, I did.
Did you ever tell Mrs. Keenan that when you delivered the uncooked turkey to the family, that Mrs. said to you, "That's nice, but I'd rather have money"?
No.
You never made that statement to her?
No, I did not.
Did you ever tell Mrs. Keenan that the family was going to lose their home as a result of what the medical expenses connected with their son, Gavin?
I don't believe so.
Don't know that it's ever a good idea for a reporter or even an intern at a newspaper to give money to somebody they're doing a story on. Note to all you would-be reporters. The witness may have contradicted her former boss about the turkey, but whose goose is cooked? On cross-examination, defense attorney Tom Melville turns up the heat to maximize some damage control.
You did have a discussion with Miss Keenan about Janet reaction to your bringing the turkey, did you not?
Yes.
And what did you tell her Janet's reaction was?
I just felt that she rather discarded it. She didn't seem really pleased.
And did Janet proceed to tell you anything about her financial condition?
Yes, she did mention the medical expenses were uncovered by the insurance that they had at the time or didn't have anymore.
And did she tell you that her car had been repossessed?
Yes.
Did she tell you that one chemotherapy injection cost more than $12,000?
Your Honor, I'm going to object. This is beyond the scope of the direct examination.
I don't believe so, Your Honor.
I was specific as to her conversation with Mrs. Keenan.
Sustained is beyond the scope.
Now, did you tell Miss Keenan that Janet told you that one chemotherapy injection cost more than $12,000?
I don't think I said more. I think I said $12,000.
And did you tell Mrs. Keenan that Janet told you her car had been repossessed?
Yes.
Did you tell Mrs. Keenan that Janet said they had a deteriorating financial condition?
Yes.
And did you tell Mrs. Keenan that Janet said they no longer had medical insurance?
Yes.
Did you tell Mrs. Keenan that Janet said the financial toll on the family has been undescribable?
I don't recall those words, actually.
Have you had a chance to review that portion of the article?
Not recently.
Okay, I mean just this second. Did you have a chance to look at that?
Just recently now, yes.
Does it refresh your recollection about what you told Miss Keenan?
Yes.
And did you tell Miss Keenan that Janet told you that the financial toll on the family has been undescribable?
Yes.
Who wins with this witness?
The turkey.
Who takes it? The uncooked turkey.
I think this is a good witness for the defense. Ms. Keenan may have gotten Ms. Causer's exact words wrong, but it seems that she certainly got the gist of it right.
That's the impression that I get, Ricky.
I think that's true. I think that although Mr. Sneddon did a good job when he was dealing with his direct, Mr. Mesereau got to come back on cross, and when you still get to the $12,000, I guess it's undescribable. I would say indescribable, but nonetheless, this situation of dire need when we know that they were collecting insurance money.
And the lack of gratitude. Howard, you're shaking your head.
Well, look, this is consistent with the prosecution beating a dead turkey to death, although they do end up with a surprise.
They do end up with a surprise, and it's not the stuffing in the turkey. Still ahead. Thank you very much. The return of La Abuela Gavin's grandmother, plus how much is riding on the testimony of the very last witness. You got to stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. As part of their rebuttal case, prosecutors are appearing to try as they might, to do some serious repair work. Are they successful? Back to the stand, the accuser's grandmother. You'll recall that she speaks through an interpreter, her native language being Spanish. Under questioning by Assistant District Attorney Ron Zonin, the witness describes what happened immediately after her daughter was arrested at J.C. Penney. Here's what the jurors heard according to the courtroom transcripts.
Miss, good afternoon.
Good afternoon.
I'd like to direct your attention, please, to the 27th of August of 1998.
That's fine.
All right. On that particular occasion in the evening hours, did you proceed to a shopping mall in the West Covina area?
Yes.
Did you go there for purposes of picking up your grandchildren?
Yes.
Was that the day your daughter Janet and her then husband David were arrested?
Yes.
When you got to the shopping mall, was either David or Janet still there? Were either one of them still there?
Janet was there, a police officer, a patrol car, and the kids.
Okay. Which kids?
Gavin and Star.
Did you take the children home with you?
Yes.
Was Janet taken by the police?
Yes.
Okay. And were you able to get your daughter out at that time?
No.
And did you then go back to your home?
Yes.
And that's your home in El Monte?
Yes.
All right. And did you stay at your home that night with your two grandsons, Star and Gavin?
Yes.
Do you know approximately what time it was that Janet and her husband David arrived at your house and took the boys?
The next day.
All right. Do you know approximately what time the next day that was?
I don't remember.
Thank you. No further questions.
No cross-examination.
Okay, how important is it next? Do prosecutors hit a home run by wrapping their case up with a videotape interview of the accuser from 2003? After jurors saw that videotape, defense attorney Robert Sanger got his chance to grill Sergeant Steve Robel. He's the police officer who conducted the videotaped interview.
All right. You may be reading more into the question than I thought there, but the fact is, if you're saying to somebody in a situation where you are interrogating them and challenging what they are telling you, that is likely to have an effect on their demeanor, as opposed to simply interviewing them and listening to what they have to say, right?
That is correct.
And in this particular case, Gavin was 13 when you did this interview. Is that correct?
Yes, he was.
And for instance, there's a part where you ask him what an erection was, if he knew what an erection was. Is that right?
Yes.
And this 13-year-old boy told you he knew what it was because Michael Jackson had told him. Remember that?
He shook his head, and I even had a hard time hearing what he said, but he shook his head as yes. I couldn't say exactly if he said it was Michael or not at this point.
Okay, whatever it is, it's on there.
Right.
Your Honor, I'm going to object to counsel's statement and move to strike.
Can't hear you.
Object to counsel's statements and move to strike?
It's actually foundational to the next question.
Well,
but whatever.
Sustained.
Yeah, we got the bailiff in the act there. That's kind of interesting. Let's go back to the grandmother just quickly. She's trying to apparently counter the idea that David, the bad dad, had time to punch the mom and inflict these bruises that the defense say come from the defendant's, or rather the accuser's husband, ex-husband, accuser's mother's husband, David. But it takes them back to the J.C. Penney incident. That's not good.
Mesereau's cross-examination summed this testimony up.
Absolutely.
How so?
He
didn't cross-examine it.
That's true. That's
Right.
true.
But there was a lot in this case about who was responsible for those bruises. We go all the way back to Jamie Masada in the prosecution's case in chief. Was it David, in essence? You know, she comes in with the strangulation marks, or is it the person from J.C. Penney? So you got to deal with it.
We know she lied under oath. We know she got money she shouldn't have gotten. The point was made.
Yeah, it seems like they could have left this alone. We're on to the good stuff now, though. Yep. This videotape, this witness lays what we call the foundation. That is, he substantiates that this videotape was taken and it's accurate as to what it depicts. What can the defense do with this guy?
Coward.
Well, probably not very much except cross-examine him. Again, we didn't see the videotape. We talked about it last week. I don't think the videotape ever should have come in evidence, certainly at this stage of the case. But again, this judge has an agenda that I disagree with, in my opinion, as I've said a lot in this case. You have to see whether or not this young man described the events differently, and hopefully you take him along on cross-examination and punch some holes in the testimony.
And we're going to see if that happens.
If you can.
And we're going to see if that happens as we continue with the defense being limited to cross-examining the mom, whoever they might call about this videotape, to the demeanor of the kid, not to the substance of what he says on the videotape. Very interesting, huh, Howard? As testimony continues, did Sergeant Robel influence the outcome of this interview?
Okay, my point is, whatever he said in response to the questions as to whether or not this 13-year-old boy knew what an erection was, you did not challenge him at that point and say, well, what do you mean? You're 13 and you're telling me you don't know what an erection is, right?
No, I did not.
You indicated you were conducting an interview and not an interrogation. So my question is, if you had used interrogative techniques in response to questions like that, you would expect to see a different demeanor on the part of the subject, no matter who it is, right?
Asking that particular question? Is that...
Sure, I was just using that as an example.
Under interrogation versus interview?
Yeah, you'd expect to see a different demeanor, correct?
Possibly.
How about just trying to make sure the kid's telling you the truth? Next, on redirect examination, District Attorney Tom Sneddon finds virtue in this sergeant's methods.
Sergeant Robel, in the course of your training, you have been to a number of classes and training exercises dealing with the specific interview of child sexual assault cases, have you not?
Yes, several.
And have you ever been to a class where they've told you to use the interrogation and techniques that you would use with an adult, with a kid in that setting?
No.
I would object, Your Honor. As beyond the scope of cross and outside the limited issue.
Sustained.
Would you ever use an interrogation technique with a child molestation victim?
No, I wouldn't.
Objection, outside the scope.
Judge, he asked specifically that question.
Overruled. You may answer.
I would not. It's...
Why?
Because interviewing a child, this person is a victim, not a suspect. And in this particular interview, I was trained in forensic interviewing. And that is interviewing and not interrogation.
I don't ever think I've heard the term forensic interviewing, but let's put that on the side for now. What do you think about this bit of a testimony?
This is hard stuff. Go ahead, Sean.
Oh, thank you, Ricky. If I was the prosecutor, I don't think I would have asked anything at all at the end. That video, from what we understand, was so compelling and so powerful.
Just let it stand.
Yeah, let it stand and let the defense look like they're nitpicking when really the video says it all.
Well, one of the things that I would have done if I'm the defense is I would have brought someone in to talk about forensic interviewing. I started vibrating on Friday when I heard that they had stopped, and now I'm still vibrating because of this. One of the things that I've worked on in L.A. in working with the Rape Treatment Center and as a liaison to the LAPD, my husband's department, is the whole difficulty with interviewing children. Yes. This is a very specialized field, and people don't understand when it's not done correctly, when it's suggestible. And you needed to show this jury that it was suggestible.
Was it indeed suggestible? Remember McMartin? Remember all of that issue? We talked about that at the very beginning. We'll get into that more as we continue when we return. The shocking announcement that caught all of us, and probably you, off guard. Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. The trial's final witness, Sergeant Steve Robel, is asked one last question about his 2003 videotape interview of the young accuser. Now, defense attorney Robert Singer wants to know why Robel didn't challenge Gavin's initial story. I want to know, too. I know you do. Here's how the jurors heard it, according to the courtroom transcripts.
And that decision is based on the fact that you assumed that this individual was a victim, correct?
I assumed to the charges that I was investigating, the alleged charges, yes.
Thank you. No further questions.
Nothing further, Your Honor.
Thank you. You may step down.
Your Honor, we have no further evidence to present in rebuttal.
Your Honor, the defense rests.
All right. Both sides have rested subject to one document?
That's correct, Your Honor.
Okay, not a lot of time. A couple things we need to talk about. One, this cross-examination, I think, goes to the heart of it. I've been in these interviews. We've all been in these interviews. You got to challenge him, albeit gently, to make sure you've got a legitimate
Unless
victim.
you go into it believing that Michael Jackson's a pedophile and you want to do everything you can to support your ability to bring charges. And that is what has happened in this case. And that's separate from whether or not Michael Jackson, in fact, molested the kid.
But then you're saying, with what's left, since Mr. Mesereau rested, that they're going to have to argue that in final argument.
Yes.
And that's a very, very difficult position for the defense to be in. According to what we've heard, you had this little boy in shorts in a big chair, fidgeting and difficult and yawning and looking down, and then finally at the end saying that he had been molested by Michael Jackson. And apparently you could have heard a pin drop in that courtroom from everything we've heard. To leave it for final argument, I say, is high risk.
And to leave these jurors over the weekend with that image.
4 days, because they're not in court today. So 4 days sitting there with that image is very powerful and I would think very dangerous.
You know, sometimes there's nothing you can do except cross-examine the interviewing officer and hope you can right or correct the problem in closing argument. If the problem is the tape was put on at an inappropriate time, in my opinion. This should have been part of the government's case in chief, or shouldn't have been allowed. And Ricky, and I think it was Sean, pointed out earlier, this was for the purposes of demeanor. Why was sound involved?
Why sound?
Yeah, we got to leave it right there, folks. More to talk about. I'm looking forward to the Saturday show already. That's it for today. Testimony may be over, but there's still a lot of drama ahead, including final closing arguments. So what do you have to do? You have to join us tomorrow, 7:30 p.m., where? Right here on E. Who's going to win? Defense? Prosecution?
Oh.